Welcome, everybody. It looks like the magic time of noon. Mountain Standard Time has come, so to respect everyone's time, we're going to go ahead and get started. My name is Christy Kimball. I'm a partner at the Salt Lake City Holland Hart office and specialize in healthcare and life sciences law. And today, both myself and Lisa Carlson, another one of my colleagues on our healthcare team, are going to be presenting about COVID-19 testing, looking at an examination of relevant federal and state laws and the compliance risks for those involved. Now that we're 6 months into the pandemic and the ground has kind of settled beneath us in terms of the various regulations at both the federal and state level, we think it's a good time to kind of look and see what has happened in regard to COVID-19 testing and the risk that we're seeing for those that are involved in testing. So with that, we'll go ahead and get started. Of course, we have this, disclaimer that we always have that in regard to this, we're not, giving specific legal advice for anybody that's on the phone. So just wanted to make sure that you saw this. In regard to our slides, we know that those did not come out beforehand, but the email that has come out with the reminders to you about this has a link to our healthcare blog where you can find a copy of these slides, so that in the future you can have a copy of these slides for yourself to review. So I'm starting out with, I wanted a picture of kind of puzzle pieces because I think it's really appropriate for, it's a good analogy for what's happening. There are so many relevant federal and state laws, regulations, agency guidance in regard to COVID-19 testing. And the problem is not all the puzzle pieces are fitting nicely. And there's some serious, implications and confusion. There's differing agency guidance. There are a lot of things that are not clear and that aren't fitting exactly right. And so part of today's presentation, the purpose is for me to help everyone involved recognize what the relevant laws are and where we're seeing some either contradictions or confusion or some problems that are being created for those involved in COVID-19 testing. I want to start out at least just giving everybody kind of an overview. At the federal level, you've got the FDA obviously involved in authorizing COVID-19 tests, but you've also got CMS involved from several different standpoints. One would be with CLIA oversight and ensuring compliance with CLIA for labs when it comes to, again, investigations, their certificates. You've got Health and Human Services, the CDC to some extent that's involved. And then, of course, the state level, you've got those that are involved in terms of interpreting state laws in relationship to who's an authorized prescriber. You've got different Department of Health that are involved maybe in direct testing and their own interpretation of their regulations. So it's really interesting just how many layers exist here at the federal and state level. So with that overview, I'm going to start with the relevant FDA regulations for COVID-19 testing. And for these tests, there are two different types of tests that the FDA has authorized. And I want to make sure, I think maybe I skipped a slide there. Okay, sorry about that. So I'm backing up here. So in terms of the FDA regulations, everybody I'm sure on the phone is very well aware that the FDA really scrambled quickly and created an emergency use authorization program to quickly get these tests to the market to try and help with the COVID-19 pandemic. They changed that a couple of times, and the guidance in relationship to what the FDA intends with this program has changed on several occasions. But I think the last time it was updated was in May, but we've got a link to it in these slides so you can look at that. So it's emergency use authorizations, right, that are allowing the COVID-19, the PCR, and the antibody tests to be utilized throughout the United States. The one thing in regard to this guidance that's come out, it's really important that people recognize in some relationship that this is non-binding guidance. This isn't law, that what the guidance that the FDA has put out, yet it's still kind of the guidance to help those that are involved to understand what the FDA is trying to guide in terms of what you need to do in relationship to these tests, the emergency use authorization process, amendments there too, when you're going to need amendments. But again, it's not binding. And I think even other agencies that are involved are forgetting this, that the FDA is not bound by this in a strict accord, and neither are other individuals in terms of that guidance. But these, again, it's just kind of guidance. And the FDA has been working really closely with participants in COVID-19 testing to try and work through things and be flexible. But I've seen other agencies that are treating it as if it's the law. In any respect, moving on, you've got two different types of tests. You've got lab-developed tests, so clinical laboratory-developed tests, and you've got commercially developed tests. And I think everybody's keenly aware now, but the FDA, you can go to their website and you can find all of the tests that have been granted emergency use authorizations. And on the website, it will also show, you can pull up a copy of their EUA. If it's been amended, it will be right there, next to that particular test. And you can also find their instructions for use, which are also being amended. If it's a laboratory developed test, it's got to be the lab has to be CLIA certified for high complexity testing. And they've got to submit to the FDA an emergency use authorization request within a reasonable time, which again, this non-binding guidance says is about 15 days after you begin implementing the testing. So you can a laboratory can develop a test, so can a commercial manufacturer. They can start distributing, having people use the test even before they submit their EUA, but the FDA expects that they're going to do that within a couple of weeks' time. The only exception to that would be that there are some states like New York that have specifically asked to be responsible for authorizing the lab-developed test under their own state law. And the FDA has generally agreed to that and said, you will be responsible for authorizing these laboratory-developed tests, and we'll stay out of it. The FDA does have EUA, I'm going to refer to EUAs, that's the emergency use authorization, but they have templates on their website, so to make it as easy as possible for those people that are developing tests. So they have a really good way for you to kind of plug in your information in the way that they'd like to see it. The FDA has also said they're not going to object to the use of tests, again, pending EUA approval, as long as its preliminary review of submitted data is found acceptable. So they kind of do a quick cursory review when they get that EUA, and as long as they don't see anything that's problematic, they are fine with the testing continuing to be used without their formal approval. And I should be careful about, I would say, using approval, the term approval versus authorized. These tests, of course, are all FDA authorized under this emergency use authorization, but it's really important to distinguish that they are not FDA approved. The FDA for these lab-developed tests, they recommend that the labs obtain confirmation of the first 5 positive and the first 5 negative clinical specimens using an EUA authorized assay. So that's just their suggestion for how to confirm that the tests are valid and you're getting valid test results. So now moving, mostly I think what a lot of people that are on the phone are more interested in are the commercially developed tests. Within the United States, you've got to have an EUA to distribute these commercially developed tests. The other thing is their instructions for use, which I'll refer to sometimes as IFUs. You'll hear people in the industry referring these to IFUs. And a manufacturer is allowed to distribute their test if it's labeled consistently with the labeling authorized by the FDA, so the emergency use authorization, but it also includes following the particular test instructions for use. The EUAs and their IFUs outline the conditions under which a manufacturer can distribute their tests and the specific equipment and methodologies that are required to be used by labs processing the tests. One interesting thing to note is that all commercially manufactured COVID-19 tests are labeled as RX only, prescription only. So under FDA law, there has to be a valid prescription for these commercially developed tests. And that's something that I'll get into a little bit later, which is an interesting conundrum that I'm seeing at least around the nation. So with these commercially developed tests, these EUAs are being amended. Initially, when the pandemic broke, and you've got manufacturers that are just trying to get an EUA as quickly as possible, get their tests out. Initially they were looking at, let's say, that they included that it was going to use a certain transport media, maybe a certain extraction method, but this was all just very quick. And also these EUAs and their IFUs, their instructions for use, were sometimes a little rudimentary. And as, of course, these manufacturers, but also the labs that are utilizing these commercially manufactured tests, as they've gained more experience and have altered, modified these tests and the methodologies that they're utilizing, the manufacturers can request an amendment to their EUA and their IFU to account for these changes that are being done kind of in real-world time to make the methodologies better as this pandemic has continued and the testing has evolved. But let's talk about the amending of the EUA. So you're required to amend, this is according to the non-binding FDA guidance. You're required, for commercially manufactured tests, you're required to amend an EUA when you're changing a specimen type. So that's, for example, going from the nasopharyngeal swab, sticking the swab up, clear up somebody's nose, to a saliva test, right? That's a different specimen. And you're required to get an amendment of the EUA when you're changing the specimen type. However, in that non-binding FDA guidance, they make it clear that outside of changing the specimen type, if you're modifying an EUA authorized test, so this test has already got their emergency use authorization, one does not need to notify the FDA or amend an EUA as long as the modified test is validated using a bridging study to the EUA authorized test. And they say in their non-binding guidance that one way to bridge to a new component is to establish equivalent performance between parallel testing of the same specimens with the new and original components. So I think that's really important. That's something that I think has been misunderstood, and I'm even seeing CMS officials not understanding this. I'm seeing state officials not understanding this. I'm seeing news reporters not understanding this. But the FDA has said that you can modify these tests without getting an amendment to the EUA and without notifying the FDA, as long as you're doing validation bridging studies to make sure that the results are still accurate. And again, that's outside of the specimen type. So what are the problems with this and what are we seeing? Several of the issues that I've seen that have come up is that if you've got a laboratory, let's say that they're using a commercially manufactured test, they're processing a commercially manufactured test. And let's say that they have modified that EUA authorized test, let's say with a different extraction method, going from, let's say, manual to automated extraction. They've changed the transport media. And some have just had to do that because there were shortages of transport media early on. So you had to bob and weave and you had to use different transport media than maybe what was listed in the manufacturer's EUA and instructions for use. Well then, of course, what the lab is doing with that commercially manufactured test, the processes and methodologies are not lining up with the EUA and the IFU that are on file with the FDA. Now, while that should theoretically be okay, we've seen issues where, whether it's due to this being such a new process, so many agencies involved, where we've got CLIA investigators or surveyors that think that that's not acceptable, that a lab has made modifications, it's using a different transport media, and they're trying to tag laboratories for non-compliance because their methodologies don't line up with the FDA filed EUA and IFU. In terms of other issues, again, all commercially manufactured COVID-19 tests are RX only. But what you're seeing, is that there are some programs, even those that are being conducted by states, that there isn't a prescription that's accompanying that order. And again, while theoretically to try and achieve the objective of what we're trying to do in this nation and all over the world is to get as much testing out there as possible to try and control the pandemic, and this should be acceptable. What's interesting is that you've seen some states where they think they're looking just their state laws. So they've got, let's say, maybe state AAGs that are looking at their state laws and say, well, we interpret that under our state law that for a test like this, there is no physician order or provider order that's needed. We think that the patient themselves can request this test and that is an authorized person under state law who can request this test. So I've seen, states that kind of are under that, that's what they're looking at is their own state law and interpreting it for themselves and helping their own state health departments make those determinations. But I think the piece that's been missed is that these tests are labeled as being RX only, that they have to be accompanied and can only be administered with a prescription. So I think some states, some entities have missed that, some have not. We see that there are some states that I think because of this very issue, they've had, let's say their state epidemiologist or, a state official that's a physician that has issued a statewide standing order for these tests. So that for any patient, meeting certain criteria, that standing order is the required physician order to receive the test. But that's something that has not happened in other states, even where, let's say, states are involved in testing. So that's an interesting aspect. So now moving to CLIA. CLIA is the second layer of federal law that you have to look at when you're looking at COVID-19 testing. The Clinical Laboratory Improvement Amendments, referred to most oftenly as CLIA, it regulates laboratory testing and requires clinical laboratories to be certified by CMS, the Centers for Medicare and Medicaid, before they can accept human samples for diagnostic testing. Labs can obtain multiple types of CLIA certificates based on the kinds of diagnostic tests that they conduct. So that's an overview of CLIA. Now, the FDA, CMS, and the CDC are all involved in some aspects of CLIA. Now, the FDA is involved in determining what level of a certificate that a laboratory needs to have, let's say moderate to high complexity certificate to run certain laboratory tests. But CMS is where I really want to focus on. CMS is responsible for issuing CLIA certificates to laboratories. So, for example, saying that they have, if they have a certificate for moderate complex testing, if they have a certificate for high complexity testing, they're responsible for inspections and for regulatory enforcement of the CLIA standards under federal law. However, the interesting part is that CMS has no authority. They don't have the statutory authority to waive the CLIA standards and conditions that are located in the CFR. So that's created kind of an interesting conundrum. And we'll talk a little bit more about that later. But CMS, the other layer that's interesting is that CMS, right, being a federal agency, they contract with state agencies. So, for example, in Utah, the Utah Public Health Laboratory, which is a division of the Utah Department of Health, is the contracted state agency to conduct CLIA surveys and investigations in that state. So you have somebody, within the state that's contracted by CMS to do this kind of inspection, look into complaints, do these surveys. So you've got these different layers of state and federal involved. So looking at CMS and CLIA enforcement, what's happening with COVID-19 testing? So CMS officials have publicly asserted that they will be flexible and assert enforcement discretion. So here are a couple of quotes from CMS about this. They've said, during the state of emergency, CMS's inspection efforts are focused primarily on addressing immediate jeopardy situations, and CMS is generally exercising enforcement discretion for activities that do not rise to that level. We've given you a link there where you can link to that statement. They've also said, while they do not have the statutory authority to waive CLIA requirements, it will exercise enforcement discretion and, where possible, is willing to explore flexibilities. So that's what the top officials at CMS have publicly stated. Related specifically to the CLIA forms, CLIA conditions, requirements, and COVID-19 testing, CMS published a summary related to changes implemented, and it acknowledges that its current CLIA forms require changes to accommodate the present realities. So, for example, they talk about documentation and record-keeping requirements for lab tests that would not be relevant in the absence of a treating physician's or nurse practitioner's order. So they're recognizing that with this unique testing situation that we have going on, that their forms, their requirements, things are going to be different, practically speaking, with how testing is being done right now. Normally, right, pre-COVID, normally you see your treating provider. Let's say you go to your primary care physician and they want you to have some lab work. You would have that order from your treating physician, and that's where you would then go to the lab and have that lab work done. Right now with COVID-19 testing, you don't have a treating provider that's often involved in that process, right? Now, again, under FDA law, that poses an interesting conundrum because it says RX only, but sometimes there's no physician or no provider involved, or sometimes you've got other types, or a non-treating provider, like somebody that's just looked through, a survey of questions to see if you've got various symptoms. Or now under federal law, as Lisa will talk about later, a pharmacist can provide an order for these tests. So again, CLIA's forms and processes don't line up with the practical realities of how COVID-19 testing is being done at this point. CMS also issued guidance to state surveyor agency directors on March 26th related to CLIA enforcement during the COVID-19 pandemic. And therein, CMS stated, in regard to, for example, alternate specimen collection devices, they said CLIA regulations are not prescriptive about the type of transport device, for example, specimen collection swabs and viral transport media that laboratories use to collect the specimens needed to perform a test. CLIA only requires that the lab follow manufacturer's instructions. If a lab modifies the manufacturer's instructions, the lab must establish performance specifications and validate the assay prior to performing patient testing. CLIA is not prescriptive as to how the study is performed. So that's, a quote from them to their state surveyors saying, look, we are not in the business of regulating and being prescriptive about these details. If a lab modifies a test, they're allowed to do that. And we're not even going to be prescriptive about how the study is performed. They just need to establish performance specifications and validate the assay. That's what CLIA regulators at the state level should be looking at. What are the problems? Despite these statements, strict CLIA enforcement is occurring, and it's been a little discombobulating to try and figure out why that's happening. There's not this enforcement discretion all the way around. CMS's guidance to its state survey agency directors related to this COVID-19 testing and about them not being prescriptive about these detailed nuances into how validation studies are performed, that's not being followed, and we've seen instances of that. Now, whether this is a misunderstanding, if these are state surveyors that just don't have the knowledge that they need, is it a disconnect between CMS and the contracted state enforcement officials? Is there just not enough good communication? I don't know. But we're not seeing consistency between what top CMS officials have publicly stated should be happening and what on the ground is in fact happening with CLIA enforcement. State survey agency directors and our CMS officials involved in CLIA enforcement, the last thing, again, I just want to point out is that these people that are involved in enforcement, what we're seeing is that they're trying to interpret and enforce FDA guidance related to this COVID-19 testing, again, even though it is not binding and even though it's outside the scope of CLIA. Right, so CLIA and the CFR goes through, you've got all the conditions and requirements of CLIA that labs are supposed to meet. And that is what normally a CLIA surveyor is supposed to be holding labs to. But when we've looked and helped clients with this, what you're seeing is that these surveyors / investigators, they are either completely misunderstanding this FDA guidance or their own guidance from CMS officials, that they are trying to, let's say, interpret FDA law. They're trying to hold, in some cases, labs accountable for saying that they're not following FDA law because they've modified a test and that's not lining up with the emergency use authorization on file with the FDA or the instructions for use. And they're citing labs for these deficiencies. So somehow, there is definitely a need that we're seeing for better interagency communication and cooperation at the federal and the state level to try and really achieve the objectives of what the federal CMS officials are stating. One other thing I wanted to mention, a recent development, is that there has been a CLIA interim final rule that recently went into place. So pursuant to the CARES Act, as of August 25th, CMS modified CLIA to require certified laboratories that perform or analyze any test that's intended to detect or diagnose a possible case of COVID-19. So that would include, PCR tests, antibody tests. They're required to report the results, both positive and negative, within 24 hours of being known. This also includes this interim final rule. It requires that healthcare facilities using point-of-care COVID-19 testing devices under a CLIA certificate of waiver, including nursing homes, pharmacies, and other settings, are required to report test results under the regulation. And failure to follow that subjects one to civil monetary penalties. Now, guidance for following this interim rule and what you're supposed to do can be found by clicking on the link that we provided in the slides. But in general, as an overview, you follow your own local rules for whether or not you're supposed to report those test results to the State Department of Health or local health officials. And then from there, they're responsible for reporting it upward. So I guess my bottom line is, despite CMS's statements, you've got to assume strict enforcement of CLIA requirements. I feel like it's not fair. Is it practical? Is it appropriate? I'd argue not. But despite that, you should just assume strict enforcement of CLIA requirements. And I would urge, there certainly are a lot of different people involved in some of these testing solutions where you've got, let's say, people that are on the ground that are doing the collections of the specimens that are sometimes unaffiliated directly with the laboratory. For example, in the state of Utah, of course, we've got an entire very sophisticated, it's pretty impressive, but a very sophisticated software system was put together, which through QR codes is tracking the patients that come to get tested, matching them with their sample kits. That data is all going, into a database. The tests are then transported to labs. Labs are then doing the testing. Results are reported out. However, regardless of who's involved in this testing, even where you've got state officials and they're the ones that have been directing the process to be followed to try and help the citizens of their state, CLIA requires that laboratories have their hands and control over all aspects of the testing process, from specimen collection to storage of the kits, to storage of the specimens, to transport to the lab, to ensuring that the proper information on the test requisition is all included and that the laboratory has that, and that they have control over test reporting. And so when you have all these different players involved, what happened up front is that there was a lot of innovation going on to try and, practically speaking, get testing working and get as much testing going out. And there were some really sophisticated, good solutions that I think everybody should have been happy with. But unfortunately, caught in the crosshairs have been some of these labs that were just trying to, do what they thought, what the federal government wanted, what state governments wanted, and doing it in a way that was really good. But technically, the CLIA conditions under the CFR were not being met. And while, again, we heard from CMS officials there would be some flexibility, we're seeing, practically speaking, that sometimes there's not. And so I would just encourage that anybody that's involved, any third parties in the labs, you need to make sure that you're carefully reviewing the requirements and conditions for CLIA, for laboratories, and making sure that the laboratory has control over all of the processes and that it is their SOPs, it's their policies and procedures that are governing the entire process. And that any third parties that are working in conjunction with them are following the laboratory's policies and procedures that the lab has created and finds to comport with the CLIA standards, because that's what we're finding is being enforced on occasion. So, those are my thoughts about, what's occurring. And with that, I'm going to turn the time over to Lisa Carlson, who will be talking about issues related to reimbursement.
Awesome. Thanks, Christy. I'm going to turn to the issue of reimbursement. And as Christy mentioned, there's a lot of players involved, a lot of moving parts when it comes to our nation's response to this pandemic. And reimbursement is not isolated from the situation where you've got conflicting guidance from different agencies. So what Christy was talking about, many of those things are going to be very specific to performance of the tests and not necessarily transfer over equivalently to what's required in order to get paid for those tests. So it just adds another element of complexity. First, there's two pieces of legislation that are critical to the issue of reimbursement, and those I have listed up here on the screen. It's the Families First Coronavirus Response Act, or the FFCRA, and the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act. I'm sure you've all heard of these. They're they cover a lot of ground, but specific to COVID diagnostic testing, the FFCRA was the first one that was enacted, and it requires all plans, both government and private, to cover diagnostic COVID testing, including items and services that are related to that testing. And it also prohibits plans from requiring cost sharing, prior authorizations, or other medical management requirements of its beneficiaries. And then the CARES Act, which was passed just a little bit later, expanded the FFCRA to include additional diagnostic items and services that have to be covered. And it also extended coverage requirements to private plans to include out-of-network providers. So these two laws, when you take them together, require most types of insurance plans to cover diagnostic COVID testing and costs that are associated with that testing. So as I mentioned, these laws impose specific requirements on both private and government payers. And first, I want to talk about private payers, starting with what types of insurers are impacted. So the obligations of those two laws apply broadly, both to insured and self-insured group health plans, including ERISA plans, plans that are sponsored by state and local governments, church plans, individual health plans, and that includes both plans that maybe are on the individual markets or on or off exchanges. And it also applies to student health insurance coverage. So most plans. So these plans that are impacted, the question is, what are the requirements? And here on this slide, I've listed the 3 general requirements, and I'm going to go into these in more detail on the coming slides, but just wanted to list the general requirements first. So plans must cover in vitro diagnostic tests and their administration. They must cover items and services that are provided during a visit that results in a COVID diagnostic test, and they must cover those things without imposing any cost-sharing, prior authorization, or medical management requirements. So turning to the first requirement, private plans must cover in vitro diagnostic tests and their administration. So an in vitro diagnostic test is essentially a test that's used for diagnosis of a disease. And currently, there are 3 types of COVID tests that are included. That's the polymerase chain reaction, or the PCR test, antigen tests, and the hotly contested serology or antibody tests. Not every test under the sun has to be covered. So there are some, there's some guidelines that the test has to sort of pass a hurdle in order to be covered or be mandated for coverage. And there's 4 ways to determine whether a particular test that's out there must be covered by a private plan. So first, plans that must be covered are those that are FDA approved, cleared, or authorized. Now, as Christy mentioned earlier, currently there's still no FDA approved or cleared tests. The mechanism for these COVID diagnostic testings is through the emergency use authorization process. So if a test has been or has received its emergency use authorization, it must be covered. And second, if a testing developer will be requesting or has requested an emergency use authorization, it must be covered. So basically, this means they're in the process, they're on their way there, they just maybe haven't quite got the FDA's final stamp of approval yet. It's intended for use by commercial manufacturers that have validated their own tests and have notified the FDA of this validation prior to distributing the test and are in the process of submitting an EUA. And you'll see on this slide, I've included some links. The FDA is listing for providers and payers for their convenience, is listing those tests that have received the emergency use authorization in that first bullet point. Second bullet point, they're listing the tests that have requested and are in process of receiving that emergency use authorization. So anyone is permitted to rely upon the fact that a test is listed on the FDA's website under either of those lists as being indicative of that plan or of that test being covered or mandated for coverage. And then on that third bullet point, some states have authorized labs within their states to develop and perform COVID testing. And in those states, testing performed pursuant to that flexibility must be covered as well. And again, there's another website or another link to the FDA's website where they list the states that have taken advantage of that flexibility. And then finally, a test must be covered if the Department of Health and Human Services determines that that test is appropriate. as of today, there are no tests that fit within that category. And then finally, plans must cover diagnostic tests that are performed at home. So these tests are not limited to only those that are performed in a clinical setting. Okay, so on to the second requirement for private payers. That's the requirement to cover items and services that are furnished to a patient during a provider visit that results in an order for or administration of an in vitro diagnostic test. This requirement essentially requires plans to cover not only the test itself, but also its administration, the office visit, facility fee, basically any charge that relates to the evaluation and testing of an individual for COVID-19. Plans must cover items and services that correspond with traditional visits, such as office visits, telehealth, urgent care, or emergency room visits. But it's also clear that they have to cover non-traditional care sites, like drive-through screening or parking lot sites, as long as those visits result in an order for or administration of a diagnostic test. And this coverage requirement includes facility fees if one is assessed as a result of that visit. Plans must also cover other diagnostic tests that may be performed in a visit where the provider maybe uses those diagnostic tests to rule out or determine whether an individual needs a COVID test. For example, a provider may order a diagnostic panel for influenza A, influenza B, RSV. They may order a chest x-ray, and then ultimately, if the provider then orders a COVID-19 test, the plan must cover all of those tests, including any fees that would be associated with them. In the example I used above, it was an x-ray. So if there's a physician fee that's charged to read the x-ray, that would also be mandated for coverage. And on the third requirement, finally, plans must not impose any cost-sharing, prior authorization, or other medical management requirements on beneficiaries who receive the diagnostic tests and items that we were just speaking about. Plans do have some protection here, as they don't have to cover every single test performed just because the patient may be curious about whether they either have or had COVID-19. So to implicate the requirement for coverage, diagnostic testing must be determined medically appropriate for the individual by the individual's attending healthcare provider based upon an individualized clinical assessment that's consistent with accepted standards of current medical practice. So these standards are really important when a provider is evaluating both the process that they must take in evaluating a patient in order to determine whether a test is necessary, and then in determining which test they're going to order. And it's important also to note that for these purposes, an individual's attending healthcare provider does not need to be directly responsible for providing care to the individual in order to be considered their attending healthcare provider. The requirement is that it simply be an individual who is licensed or otherwise authorized under applicable law, who is acting within the scope of the provider's license or authorization, and who is responsible for providing care to the patient. So it's important to note that the responsibility lies or rests with that attending healthcare provider to determine what type of testing is medically appropriate for the individual based upon that individualized clinical assessment. And of course, based upon current accepted standards of medical practice, so community standard of care. And as many of you are aware, there's been a lot of controversy over whether antibody or serological tests are covered or should be covered. And Largely, that's due in part to the FDA indicating that antibody tests early on, they indicated antibody tests should not be used as the sole basis for diagnosis. But guidance is now clear that antibody tests must be covered if they satisfy the other requirements of the FFCRA and the CARES Act. So this acknowledges that there are circumstances where a serological test is medically appropriate for an individual, so long as, again, it's determined medically appropriate by that attending healthcare provider based upon a clinical assessment. So, and then finally, there are no limits to the number of tests that are mandated to be covered for a particular individual. Again, as long as each one of those tests that's performed satisfies the other elements that we just discussed. Okay, so what about public health surveillance testing or employment screening? That's another hot topic item. Plans are only required to cover items and services that are used for diagnostic purposes. So there is no obligation for a plan to cover screenings that are used for general return to work programs or public health surveillance purposes, only if it satisfies the elements on the previous slide. Now, the Act also impose requirements on how much these plans are required to pay. So generally, a plan will reimburse an in-network provider at negotiated rates for COVID testing, and they'll reimburse providers at rates for other items and services that were negotiated pre-pandemic. But for out-of-network providers, there's two things that you need to know. First, the CARES Act requires that providers that perform diagnostic testing for COVID-19 publish their cash price for those tests on their public website. A provider's failure to publish that cash price can actually result in the imposition of civil monetary penalties in the amount of $300 for each day of noncompliance. So it's important to get those cash prices posted if you don't already have them posted. And then secondly, plans are then required to reimburse out-of-network providers at this publicly posted cash price. And of course, the parties are always free to negotiate other rates for reimbursement. Timing. So how long are plans required to comply with these requirements? So the guidance and the FFCRA and CARES Act have both made it clear that the coverage applies retroactively and covers any items or services that were provided on or after March 18th, 2000 of this year, 2020, and through the duration of the public health emergency. Some plans have extended this coverage beyond the end of the public health emergency, but it's something you'll just have to coordinate with private plans to determine what their end date is. And for reference, the public health emergency was last extended on July 23rd by the Secretary of the Department of Health and Human Services. And each extension lasts 90 days, so that takes us through almost the end of October. Of course, the public health emergency can be terminated affirmatively earlier than that, and it can also be extended again at that time or before it expires. And so far we've covered federal requirements that are imposed on payers, but it's important to remember that nothing prevents a state from imposing additional standards or requirements on insurers that are operating within their state. So I've posted a link to a few state bulletins here for your reference. If you don't see your state listed, you'll want to check with your state insurance department to see if they've published applicable guidance that may be helpful. And then my last slide related to private payers, I've just listed a link to the FAQ documents that were issued related to interpreting the requirements of the FFCRA and the CARES Act. It's a joint agency guidance. It was issued by the Department of Health and Human Services, the Department of Labor, and the Treasury. So if you haven't checked that out, you should read those. They're very helpful. Okay, now moving on. Next, I'm going to cover government payers, specifically Medicare, because most states' Medicaid programs track Medicare requirements, but can also be specific to the states. So I'm going to go through these relatively quickly, as there's a lot of guidance out there already from CMS and various Medicare administrative contractors, or MACs, about claim submissions, various requirements, reimbursement rates, what coverage is available. But essentially, it's very similar to that of private payers. Medicare is covering in vitro diagnostic COVID tests that are reasonable and necessary. And according to CMS, this means that the beneficiary has a known or suspected current or prior COVID-19 infection, and where the testing is medically necessary, essentially to establish or rule out a diagnosis. And similar to private plans, there's no coverage available for return to work or surveillance testing that is not diagnostic in nature. Other diagnostic laboratory tests are also covered, similar to private plans, including diagnostic x-rays, fees related to specimen collection and testing. So if a provider were to run an influenza panel and a chest x-ray, those tests would also be covered. But there is one item that Medicare covers that private plans are not required to cover, and that is counseling that's given to patients on the importance of self-isolation following a test. There's various elements in CMS guidance as to what that counseling is recommended to cover, including, how to self-isolate, what resources may be available. So certainly if you're going to claim counseling, if you're going to code for that and seek reimbursement, you should check out the CMS guidance regarding what elements they suggest including in that counseling. And one thing we talked about, or Christy talked about a lot, is whether an order is required. And this is a confusing topic because it is so inconsistent. Even CMS has changed their mind about whether orders should be required. So initially, generally Medicare requires a provider order for diagnostic lab tests. And initially they determined that in the interest of increasing testing and making it easy and accessible, that a provider order would not be required. But then later they changed their position on the basis that unlimited testing without provider involvement would potentially increase the risk of fraud, abuse, and waste. So effective on September 2nd, they've limited the number of tests a beneficiary can receive without a provider order. This is based on the rationale that if you allow a beneficiary one test, it gives them access to urgent testing if that ever becomes necessary, but then it also allows them an opportunity and a reason to seek out medical care that they may need for subsequent tests in order to ensure appropriate follow-up and accurate interpretation of test results. So current status is that for diagnostic tests, Medicare will cover one of each type of diagnostic test without a provider order. And then after that, provider order will be required. Medicare has also relaxed the types of providers who can order these tests. So advanced practice providers and pharmacists are now permitted to order, and that's as long as doing so is consistent with state scope of practice laws. And then at the bottom is a requirement that's imposed upon laboratories that are engaged in patient testing. And it's that if a laboratory is involved in direct patient testing, they must notify the patient of the results directly. Medicare has also expanded the coverage of COVID-19 testing to comply with CDC guidelines that are applicable to nursing homes. So I won't spend a lot of time on this because it's somewhat nuanced and very specific to long-term care facilities. But given the significant implications that a COVID outbreak would wreak on a long-term care or nursing facility, testing is occurring more frequently, and it is including the testing of folks that have been exposed that are potentially asymptomatic. And the purpose for that is to have early intervention to prevent potential outbreaks, which can be devastating. So the links that I've included on this page are helpful if you're interested in more information about coverage for skilled nursing facilities or assisted living facilities, which are more state-oriented, but many of them have taken guidance from these guidelines. The second link is a very helpful flow chart that CMS has put forth about how payment determinations are made. So definitely check those out. And then for dates of coverage, Medicare is covering testing again dating back to March 18th, similar to private plans, and throughout the public health emergency period. And I've also included another link if you want more information about Medicare billing. That has a lot of helpful information there. And then finally, resources for getting reimbursement for uninsured patients. There's a few options. So first, depending on your state, some states have elected to add the optional Medicaid eligibility for uninsured patients, and that's for the purpose of providing COVID-19 related diagnoses and treatment. This is obviously state specific, so check with your state Medicaid department to see if they have offered that expanded coverage. The Health Resources and Services Administration, or HRSA, as most of you probably know of it, also has a program available for providers to submit claims for COVID diagnostic tests and treatment that's provided to uninsured patients. Theirs dates back to February 4th, 2020, and claims are reimbursed at Medicare rates. And then finally, for those providers that receive provider relief funds, these are intended to cover COVID diagnostic testing as well as many of the other unanticipated COVID costs that providers are experiencing these days. And my final slide is just a few claim submission tips, and these are more geared towards submitting to private payers. But, the best tip I can give is to work with your payers in advance of your claim submissions to identify what types of documents that they're going to require for a successful claim. So many of these providers are making this information readily available on their websites or through training seminars or documentation that they're sending out as to, what do they need to be able to identify that a test was medically appropriate or that it was ordered or indicated by an attending provider. And also, what type of information do they want about what type of test was selected and used to make sure that it fits within one of those 4 categories that we discussed earlier, and potentially maybe it's not, it doesn't have an EUA yet, but how do you communicate that to your provider as to why you've selected an appropriate test. And then ensure you're using appropriate claim codes. There's a lot of claim codes. It seems like they've expanded, they've ballooned over the past several months, so it could very well be using outdated or not appropriately specific claim codes or modifiers. And then, of course, monitoring for new codes and new guidance is always really important, whether that's private payers, Medicare, or Medicaid, going straight to your MACs for advice on what they want to see to make sure your claims are successful. Some of the new guidance has slowed down. It was coming at us really, really fast and heavy in those initial months, but it's sort of slowed down a bit and giving everyone an opportunity to catch our breath. And so it's possible that there's new guidance out there, so always be on the watch for those. And with that, it looks like we are right at time, but here is our contact information, and the slides will be available at the link that's at the bottom. I think there's also a link in the email that you received, as Christy mentioned. And if you have any questions at all, please don't hesitate to reach out to either one of us. We're more than happy to help and answer any of your questions.
Thanks for joining, everybody.